Good evening, everybody, and welcome to tonight's Planning Control meeting. Before we go on, can I just ask you all, if you've got mobile phones, either switch them off or put them on silent, please. Thank you. Moving on to the agenda. Apologies from anybody? No? No, we've got a full house. Late items to be introduced by me, there are none. Declarations of interests? No. Minutes of the meeting held on the 14th of September 2017. Noted, thank you.
Chair, sorry, just at this point, could I just let everybody know that an additional representation that was received today has been passed around to members for their information. You've got a copy as well. Thank you. Minutes of the meeting of the Conservation Area Advisory Committee held on the 7th of September 2017. Thank you. Item 6 is the appeals decisions. Ian.
Thank you, Chair. Just one item to report in your papers tonight. This is an appeal we had against the refusal of planning permission for an extension at 4 Primula Way in Littleover, right on the edge of the city. It was the site forms part of a small cul-de-sac in a residential area, and full planning permission was sought for a first floor extension over a front ground level integral double garage. So it was quite a big forward projection at first floor level. Would have provided the householder with about 25 square metres of extra floor space, and we had concerns about that visual impact within the context of the street scene. So we refused permission under delegated powers. They took it to the planning inspectorate under the 12-week fast-track regime. And in this case, the inspector concluded that in this location, where it's a fairly small cul-de-sac street scene with a varied mix of house types, that the proposal, whilst large, wouldn't be unduly detrimental to the overall character of the street. So allowed permission with 3 standard conditions. So you know, we take a good look at these decisions, and we'll take that on board when we make future decisions. So that's the only one on the scoreboard tonight, Chair. Thank you.
Thank you, Ian. Moving on to item 7, applications to be considered tonight. And the first one is what we're all here for, I think most of us. Pages 1 to 40. Unit 7, North Edge Business Park, Alfreton Road. To tell us about this is Paul.
Thank you, Chair. Housekeeping, if we take members to page 36. Condition 10 therein should refer to the air blast cooler units rather than the waste processing compound. But other than that, I'd suggest the conditions as on the report. Your report identifies the relevant issues and the constraints, and as you may recall, has been the subject of external barrister opinion and deferral, and has arrived now at this crafted report. There has been an excessive amount of scrutiny, late submission of information and consequent delay. We are now in a position with a robust report to debate the merits of the scheme as outlined in your report. It's a long report, but it covers all the issues I think that we need to bring before members for a debate. The proposal is in an existing industrial building in an industrial location, which was previously a concrete manufacturing plant that was subject to its own environmental permit. This proposal seeks planning permission for the testing of new technology based on pyrothermic conversion and the erection of external 20-metre high chimney stack, all for a temporary 18-month period. You will note the industrial business location. It's in the buffer zone of the World Heritage Site and next to the World Heritage Site boundary. The flood risk zone and the presence of the Our City, Our River flood defence barriers. and also the proximity to residential property some 20 metres distant on Mansfield Road. For those members that attended the site visit, you will recall the large size of the building and the makeup of the area. The new chimney, external to the building, would project some 7.5 metres above the existing building. In detail, the proposal will be testing the operation of waste-to-energy technology for an 18-month period to establish an efficient system that is capable of providing reusable energy. Operationally, it would run for 100 hours a week, Monday 8 a.m. till Friday 12 noon, with deliveries 8 a.m. till 8 p.m. Monday to Thursday. The application was formally screened under the Environmental Impact Assessment Regulations 2017, and it was determined that the proposed development is not EIA development. There were, however, submitted in support of the application several technical documents referred to on pages 3 to 6 of your report under the headings Air Quality Assessment, Health Impacts Document, Noise Impacts Assessment, Flood Risk Assessment, Heritage and Landscape Assessment, and Ecology Appraisal. You will note from the report there are no objections to the proposal from the Health and Safety Executive, from the Highway Authority. Derbyshire Wildlife Trust advised that the proposal is not considered to have any significant adverse ecological impacts. The Environment Agency has no objections, and neither has Land Drainage or the County Archaeologist. The Environmental Health Officer has scrutinised this application being familiar with its nuances, and has recommended conditions where appropriate to sit alongside the existing environmental permit, which controls the operations of the proposal under the Pollution Prevention and Control Act 1999 and the Environmental Permitting Regulations 2016. And for members' comfort, it is summarised as appended to the end of your report on pages 38 to 40. In terms of impacts on heritage assets, it is of note that the Conservation Area Advisory Committee do not object. The Derwent Valley Mills World Heritage Site Conservation and Planning Panel, who are charged with assessing the specific impacts of the proposal on the World Heritage Site, take us through their consideration on pages 23 and 24. To conclude in a very pragmatic way that the World Heritage Partnership does not feel that the proposed development will have a negative impact on the reasons for the inscription of the World Heritage Site and consequently its outstanding universal value. My Conservation Officer helpfully explores the heritage appraisals that have been submitted and heritage and impact on the heritage assets, noting on page 22 Historic England's response, and concludes satisfaction that through an analysis of the submitted information has been carried out, including the relevant UNESCO guidance, and that the full range of heritage assets have been properly considered. On page 22, I've reproduced in bold the Conservation Officer's conclusions, that the proposal will have a slight overall impact, which is negative, the harm being less than substantial, and in accordance with National Planning Policy Framework paragraph 134, that harm to those heritage assets needs to be weighed up against the public benefits of the scheme. These benefits are listed on page 26 and in the context of paragraph 134 of the NPPF, expanded on page 30. And they are bullet pointed as advancing and testing technologies that could deliver renewable energy benefits from waste processing technologies, advancing and testing technology that could deliver electricity generation, reduction of waste to landfill during the 18-month testing period, which is of course sustainable waste management, and reduction in carbon emissions. In conclusion, this application should be determined in accordance with the development plan, the local plan. It complies with the local plan part 1 and the overarching National Planning Policy Framework guidance. In terms of public benefits, these are significant, particularly with regard to economic and environmental benefits of the new technology for energy from waste and diverting waste from landfill. There will be some harm to the heritage assets, albeit for a limited 18-month period, but that harm is outweighed by those public benefits. Overall, my judgment is that the application is to be regarded as being in accordance with the development plan as a whole and the NPPF. Significant weight is given to the analysis of the World Heritage Panel's view, to the wider heritage impacts as assessed by the Conservation Area Advisory Committee, and your Specialist Conservation Officer applying the UNESCO guidance, and in accordance with paragraph 134, the necessary balancing exercise has been carried out. In my opinion and judgment, taking on board the respective consultee comments, the public benefits are significant and outweigh the harm to the designated heritage assets in this particular case. In my judgment, there are no reasonable planning grounds to resist this temporary use for the reasons explored in your report. Thank you, Chair.
Thank you, Paul. We have a number of speakers on this, as you can imagine. The first one is Mr. Morris from EnviroFusion. If you'd like to come up, please. Good evening, Mr. Morris. You have 3 minutes.
Sorry, just press the red button. That's it.
This planning proposal before you today is a first step towards commercialisation of a thermal process technology that has been developed in Derby by local engineers and entrepreneurs who've spent considerable time and effort getting the technology to where it is today. I'm Derby born and bred. I live in Bredsall, as does my 87-year-old mother. So the issues raised today by those objecting to this planning application are clearly something I thought through in detail from a personal point of view. Our project proposal at Alfron Road is designed to be temporary, and it's not a commercial enterprise, as it doesn't have the capability to produce power, and therefore we are asking for this short period of time to build our plant and then operate it for 12 months, after which it will be taken down. As well as helping the energy sector to decarbonise energy production, this technology, when deployed commercially, will compete with fossil fuel energy at equal pricing and will be able to operate without subsidy. This will be an important step towards the removal of subsidies in this sector, as well as diverting waste from landfill, a significant public benefit. Our plant already employs local people and will employ an additional 16 local people as soon as we can get the plant built. We're using state-of-the-art clean-up system with modern pollution control as used successfully elsewhere in the UK. Operating at high temperatures to meet process requirements, we ensure that pollutants are broken down to their component chemical parts, thereby no longer providing a risk of exceeding emission limits as imposed by other permit. The maximum capacity of the plant will be determined by the tonnage, not the calorific value of the feedstock. In a letter submitted to Derby City Council, Senior Planning Officer Mr. Adrian Farmer, the Heritage Coordinator for Derwent Valley World Heritage Site, said of the 20-metre chimney, the partnership does not consider that this will have a dominant presence in the setting of the World Heritage Site, particularly as there are also a number of other strong vertical elements within the industrial park and from the adjacent sports fields. We have an environmental permit for the proposed operations already given. This should give the committee confidence that the proposal is safe, time-limited, and will be appropriately monitored and managed. Potential slight impacts on one property in terms of noise are based on worst-case situation, which is unlikely to arise given that this will only occur in specialist conditions when heat waves occur. The air quality assessment that we've done demonstrates that any impacts would be negligible over a lifetime, but the proposal is for only 18 months, and this includes preparing and decommissioning test facilities, so much shorter in practice. There is no objection from the Council, EHO, or from other statutory consultees on air quality, as we've already heard. We request that you consent to this application today. Thank you.
Thank you, Mr. Morris. Can we have Mr. Steer? Good evening, Mr. Steer. Again, you have 3 minutes.
Good evening, ladies and gentlemen. The consequences of accidental fire or explosion are high, and the magnitude of such accidents is also high. the words of EnviroFusion in their document, Environmental Risk Assessment. You do not have this document? Why? The probability of fire and explosion occurring is low, but in the vocabulary of risk analysis, there is a probability of very low, which puts low into perspective. 130 metres from the proposed incinerator is Energas that holds propane, butane and other explosive gases. Fire and explosion debris from the incinerator could lead to a catastrophe for the surrounding area and the World Heritage Site. 10 years ago, DEFRA ploughed millions of pounds into a scheme to develop 3 incinerators very similar to Alfreton Road. Not one is running today due to excessive emissions, fires and explosions. The operation and monitoring of the running of this plant are described in this document, which you do not have either. There are 14 or so independent stages where failure of any one could jeopardize the integrity of the whole. The creation of deadly dioxin and furan emissions occurs most frequently at startup and shutdown. There are 52 such scheduled events and possibly another 50 allowed due to adjustments, breakdowns, etc. These nasty gases can and do reform in the process of cooling the gases before emitting from the chimney. But monitoring will occur only twice in 12 months, scheduled running of the plant. Is this safe for an unproven plant? There is no guarantee of success with incinerators of this kind. There are problems with the use of the solid recovered fuel used in place of RDF. If you go into the lower qualities of SRF, you will find that they are in fact dirtier than RDF. EnviroFusion have not considered anywhere in the implications of using SRF. This is not a normal planning application requiring consideration of aesthetics, massing, traffic, loss of light, and dare I say it, bike sheds. It requires consideration of aspects not specifically covered in the local plan or NPPF. I ask you to reject this application on the grounds of unquantifiable risk and the safety of people, the environment and heritage.
Thank you, Mr. Steer. That was well timed. Yeah. Next speaker is Mrs. Beck. Good evening, Mrs. Beck. I hope you finish on time like the previous speaker.
This proposal will cause harm to a heritage asset that is now not in dispute, and that is a heritage asset which has global significance as a World Heritage Site. It's well established in law that any level of harm to a heritage asset, even at the very lowest level, will result in a strong presumption against the grant of planning permission. I'm referring to the case of Forgefield Society against Sevenoaks District Council from 2014. The government's National Planning Policy Framework, paragraph 12, requires that great weight be given to the conservation of a heritage asset, that the more important the asset, the greater the weight that must be given to its conservation, and that harm or loss of any magnitude will require clear and convincing justification. Here, we are talking about harm, established harm, to one of the most important heritage assets in the country, as decided by UNESCO. The planning officer says that you should nonetheless grant the application on the basis that the public benefits outweigh the harm to the World Heritage Site. In fact, that assessment of harm as against public benefit is one for you and you alone to make. We ask you, as our elected representatives, to make it with the people of Derby in mind. The reason planning decisions are made locally by local councils is to ensure that those affected by the decisions are able to have a voice. Today, you are our voice. The proposed development will be of no public benefit to the local people of North Derby. The overwhelming response against this proposal makes that plain. People here are concerned about the harm to their health and their local area. The experimental nature of the development means we cannot know the effect on our air quality, as the predictions are based on air modelling alone. The public benefits relied on by the planning officer in his report are, at best, speculative benefits for the world at large. You are being asked to agree that the heritage assets of Derby North should be harmed in order for the world at large to potentially obtain some benefit from the development of this technology. That is not a clear and convincing justification for harming a site of such national and indeed global significance. You're being asked to make that decision without even being presented with an options assessment to show whether or not a more suitable location has been considered for this experimental development. There ought to be an options assessment. In reality, it is not the public, but only EnviroFusion Limited that stands to gain any benefit from allowing this proposal. We could even risk losing World Heritage status if the character of the site is damaged, as has been threatened in both Liverpool and at Stonehenge. Please do not allow the interests of this company to be chosen over a World Heritage asset of outstanding universal value to all humanity. Please refuse it.
Thank you, Mrs. Beck. Next up is Councillor Repton. Don't forget it's only 3 minutes.
Planning law is now so skewed towards developers that officers, fearing expensive appeals, often recommend acceptance of proposals that they themselves are not entirely happy with. Ironically, councillors, under the government's localism legislation, have the ability to reject applications that they feel are not right for this city and its people. Tonight, I am urging all councillors to exercise their rights under this legislation on behalf of the people of Derby who are there meant to represent. I believe, in spite of the half-hearted, qualified reassurances you'll hear this evening, that not only is this application wrong, and not only is it inappropriate, but I believe it's potentially dangerous. On page 7 of the report, you have 20 sound legal reasons to reject this application. Not only is this application wrong for this site, as it will be next to the historically important World Heritage Site and adjacent to 2 conservation areas. Not only is it wrong because of the emissions of potentially dangerous chemicals. Not only is it wrong because of the 100 hours it will operate each and every week with increased pollution and many more dangerous lorry journeys through a heavily populated residential area. Not only is it wrong because of the unacceptable levels of noise, smells and pollution. It is wrong because it presents a clear and present danger to local people and their families. This site is adjacent to Ennergas. Other similar facilities elsewhere have failed, and this facility, which is quoted as experimental. God help us all, experimental. My constituents are not guinea pigs and never will be. This application, if it is allowed and anything goes wrong, each and every one of you on this committee will be held to be collectively, individually and personally responsible. But I know you are all independent-minded, intelligent, decent, reasonable people. And I urge you not to play fast and loose with people's safety. Use your powers under localism legislation. Reject this appalling application. Thank
Thank you, Councillor Repton. Mr. Clark, would you like to come back on some of them points?
Thank you, Chair. The environmental permit, which isn't a planning application, it's dealt with completely separate from the planning process, controls the monitoring and managing of what happens at the plant. The proposal is to use SRF, solid recovery fuel, and that is controlled by the permit as well. And the air quality, what comes out of the chimney stack, is controlled by the permit, not a planning application. We're here to look at the testing of a pyrothermic conversion technology in that big industrial building. It's a B2 for the planning committee. B2 is a general industrial building, not light industrial, so it can take place on this site. General industrial building in an industrial location. It was Hanson's Concrete. It was pretty noxious when it was there. That had its own environmental permit to control what they did. Again, separate from planning. In terms of whether this site or another site was considered, that's not a planning matter. We're faced with this planning application in front of us. Is this site, the site on the screen, is that site, edged red, suitable for this proposed use? And is that chimney suitable in that location? That 20-metre tall chimney, of which 7.5 metres sticks above the top of the building. In terms of harm, to the World Heritage, it's harm to the setting. Therefore, paragraph 134 of the MPPF does apply, and we have to weigh that in the balance. We've said in the report, our conservation officers looked at it and said, yes, there will be harm, but you can weigh that in the balance. And we specifically consult, as you would expect, the Derwent Valley Mills World Heritage panel, planning panel. It's on, I can take you to page 23 of your report. At 5.10, that is their response. So following down page 23 over to page 24, where they take this very reasoned, pragmatic approach looking at the impact of the proposal, granted primarily for the chimney, on this World Heritage site, and they conclude at the end that they don't feel the proposed development will have a negative impact on the World Heritage site or its consequential outstanding universal value. It's no objections raised there. There's no objections raised by our conservation officer. And as you would have realised, our report has been through two external barristers who critiqued the report, the applicant's barrister who advised on the merits of our previous report, and our own barrister has been through this report and is content with the approach that is outlined in your report, the step-by-step approach that's taken in regard to the MPPF and paragraph 134. At the end of the day, we're being asked, is this industrial use acceptable in this industrial building with that chimney? No. And my recommendation to you, for the reasons outlined in your extensive report, is that it is. Thank you, Chair.
Thank you, Mr. Clark. Nobody else is it apart from members of the committee. Okay. Anybody from the members of the committee would like to comment on it? Councillor Harwood.
Thank you, Chair. There's no doubt that the amount of waste that is increasing all the time does mean that we have to consider ways and means of utilising it in a better way than just sending it to landfill sites or even abroad. However, this particular site, to me, is a real problem. I cannot understand, if it's temporary, why they need to have this site. Why not have a site away from areas that really, quite honestly, a lot of people, animals, birds, etc., could, in my opinion, have a problem with this particular application. What are the pitfalls of the application? Well, it's experimental. Nobody can be positive, no matter who they are. It will not do any harm to humans or any other living beings. Should a problem occur, like a fire or other unacceptable reaction, what are the likely outcomes to be? Is it worth the risk? Any application of this nature should surely be well away from residential areas, schools, places that people will congregate. In the area, there's Derby Rugby Football Club, 2 rowing clubs, both attract crowds. Also, the water is nearby where fishing takes place. And this particular application, who knows, may well pollute the water, and that would affect the fish and also the wildlife. It's close to an area of considerable interest, the heritage site. This site is of considerable importance, not to the area it is, but to the city of the old of Derby. No risk should be taken to undermine this project. Alfred Road leading to his site is busy throughout the day. I don't live far away from there, and close to this proposed site is a sharp bend. It's proposed that 16 lorry movements will happen each day for 4 days, and this road is certainly unsuitable for that amount of traffic. In any case, it could cause considerable damage to the lovely houses nearby called Tomlinson Cottages. In conclusion, this application is completely in the wrong place. I'm not against the application, I'm against the place where it is. And for that reason, I can't support this application.
Thank you, Frank. Lucy.
Thank you. So one of the objectors commented that there have been a number of other attempts to be able to deal with waste like this, and so far it's been unsuccessful. I know that quite a lot of our UK waste goes overseas at present into some sort of energy from waste system. This would be, as I understand it, a more compact way of doing it, and it would mean that, you know, in a post-Brexit world, we wouldn't be having to negotiate and probably pay even higher costs for sending our waste overseas. So there is clearly, you know, the comment somebody else meant that, you know, there might be some harm locally for 18 months, but potentially there could be a global benefit. If that's the case, then that could be a real feather in Derby's cap. And we could be saying that this is something that Derby has achieved. So I don't think we should throw this out and say it's something that we never want, because it is looking to the future. If we don't look to the future in the right way, then it's not going to be an explosion at one small point of the heritage corridor that is a problem. It's going to be climate change destroying it forever. And we need to be looking at the bigger picture, even if we also have to look at the really small picture. So I have several questions, because yes, this is a development. It is an industrial area. It's an industrial use on an industrial site identified through our local plan process. And that's one of the positions we've got to take as a planning committee. If local people don't think this should be an industrial area, then we will be moving forward into the next cycle of the local plan process, I guess in the next 5 years or so. And local people need to take attention to that and see if we can make good arguments for this area no longer becoming industrial. But we are where we are at the moment, and as a committee we have to consider our current position, not some hypothetical position in the future. So I'd like to know a little bit more about the permit system. Does the permit look entirely at the process, or did the permit also consider the location? Because the principle of saying this equipment somewhere is different to saying this equipment here, and I'd just like to know whether that permit system does one or the other. We also know that there will be emissions, and the monitoring of those emissions I'd like to know a bit more about. How do we ensure it's independent? There was a comment that it's only going to be monitored twice a year. How does that work? Can we have that explained to us, please? The third thing
is the condition to say that after 18 months, that's it? What if this is unsuccessful and after 16 months the company goes into liquidation and disappears? I want that chimney to come down. I don't want it to be left there as an eyesore at the end. So I don't know what the mechanism is. When we have no money, the company's gone, we want the chimney down. How can we manage that? How can we ensure that we as a council are not left with a liability to take that chimney down? Can we condition that in some way? Can there be a sum of money handed over to us to ensure that we can take it down if the company can't? There was also concerns being raised about flammability and the risk of a potential explosion causing damage in other businesses nearby. And I'd like to have a little more idea about the risk of that, and also the risk not just to the storage of gas in compressorised vessels nearby, which I believe is what it is, but also to cars in the car park. And my way of thinking is that cars in an adjacent car park could be more of an explosion risk than something that is already contained in a strong pressure vessel designed to withstand quite a lot of mistreatment. And the final point is really how important is whether you have any assessment about how important those are against the assessment that it's been alluded to that hasn't been done by the Heritage Trust in looking at the air quality element of that, in that they were looking only at the chimney impact and not at the air quality impact of that. Is it therefore our remit to look at the air quality impact on the heritage, both of the heritage corridor and also areas like Nutwood next door? Is that our duty, or is that something which came under the permit system? Thank you.
Thank you, Councillor Kerr. Mr. Clark, would you like to come back on some of the questions there?
Before inviting Carl to speak, there were 2 points raised, both concerned about Councillor Harwood and Councillor Kerr about wildlife impacts and Nutwood. Derbyshire Wildlife Trust have no objections to the proposal, so they've taken on board their remit, their focused remit, and assessed the proposal and come back to us and said there's no objections. This is, I've said it before, a general industrial area, a general industrial activity with that extra safeguard of a permit which controls the process. Now, the testing process is not the activity of an incinerator. It's testing an incinerator. So if you were to approve it tonight, you're not approving an incinerator on this site, you're improving the testing of that activity. So being able to test a function, it's not a commercial, fully grown incinerator like we have approved at Sinfin. The air quality that Councillor Kerr referred to is controlled by the permit, and I'd endorse Councillor Kerr's comments about the next local plan to the members of the public. Get involved to the planning process and the local plan as we draw up policies and proposals for 2028 onwards. It's everybody's city. Get involved in the planning process in allocating sites for housing, for employment uses, but currently this site is allocated for the uses that are taking place on it for our general industrial business use purposes. Other than that, Chair, I think the other points were for our environmental health officer. Thank you,
Mr. Clark. Carl.
Thank you, Chair. I've got down, I think, 2 main questions that that Councillor Kerr raised. Hopefully I can help to clarify. First of all, was the question around whether the permit looks at the specific location or just the process. The answer to that is the former. It's the latter. It's the process rather than the location. So it would be more of a planning matter relating to the location. The permit has a number of emission limits that are in effect the same right across the board for this size of incinerator, wherever it may be, and they come straight out of a European directive, the Industrial Emissions Directive, so that's irrespective of where it would be, and they are
health criteria, based on sort of World Health Organization health criteria values for the most, and that is general limits that will limit general exposure based on general background, so they aren't specific to the location. What I would say about this location, and I know there's obviously differing opinion in terms of how appropriate the location is, but for a use like this, I would suggest it is substantially a distance away from residential premises and schools and that sort of thing. In practice, with a chimney stack the height that this is, the significant dispersion you would get from that means that you're talking meters rather than kilometers, as people have the impression of, before the levels are just so small from a process like this that they are just almost non-existent. So when people talk about schools and things, those kind of distances, and the air quality assessment did pick those receptor locations, by the time that any emission had got that far, it would be so minute that it would be incomprehensibly small. So when we're talking about the nearest residential here, we're talking about 200 metres to the nearest residential premises and to those premises. And most of these emission limits, again, the other point to make in terms of exposure is that they're based on annual averages. So it's the exposure over the course of a year. So that's why you generally consider things like residential premises or schools where people would spend the majority of the year at those locations, and it's the average over the year where the emission limits are set. In terms of the monitoring of emissions, a little bit of clarity about how that works, because I think there's probably some misconceptions about how that works. I did present in the environmental permit summary, which you do have at the back of the report, the things that are being monitored under the permit. There's a series of pollutants that will be monitored continuously, and there's a list of those in the back, but things like nitrogen dioxide, carbon monoxide, particulates, they are being monitored by the system in the stack constantly. And then when people refer to the twice over the year, it's actually technically 3 times, because there will be some there will be a set of testing that will be required as a prerequisite before the 12 months comes into effect. So it'll be part of the commissioning phase before it actually starts fully operational. So there will be some emissions testing at that stage. And the way that that works is, the reason why you have to separate the two out is that the extractive monitoring, as it's called, is literally you take a sample of air from the stack and you have to send it to a laboratory. There is no way that you can continuously monitor. It's just not possible under current science to monitor continuously some of the things that people talk about, like furans and PCBs and pHs and those sort of things. It has to be something you send off to a lab. You can't monitor them continuously, and that's why you can't just keep sending samples off every day. And, I'm sure, irrespective of no concern to many of the objectors, but, it is very expensive to send those samples off and take them. So that's part of the reason for it. And I think in a process like this, normally you would only ask for extractive monitoring once a year, and I think we've recognised the concerns, and I think we've actually added, with the consent of the applicant, that there is concern here, and we've required that more than would normally be required under the Industrial Emissions Directive. I think hopefully that helps to explain. Yeah, so that's not something, that's more of a health and safety issue rather than necessarily the permit issue. It'd be a question more for the health and safety executive, I suppose, but yeah, difficult for me to comment really in terms of those risks, I'm afraid.
Thank you, Carl. Paul.
May I just come back, Chair, on one point there, in that if this initial assessment of samples sent away to a lab comes back and shows excessive levels of some of these contaminants, what happens?
If that's during the commissioning phase before full operation, it is a prerequisite of the permit. There is a condition in there that says if the plant cannot be demonstrated to comply with the emission limits within the commissioning phase, then the permit cannot operate, the process cannot operate under the permit. So until such time as the operator can demonstrate that they will be complying with the limits, they cannot continue into the 12-month permit operation. So that is inbuilt into the permit as a condition.
Thank you, Carl.
Yeah, I think this is quite a key issue. So can I just sort of go through the steps here? So we set the plant up, we set it running, we think it's running smoothly, maybe, I don't know, 6 hours, 12 hours into running. We take a sample, we send it away to the lab, the result comes back 2 days later, 2 weeks later, 2 months later. Oh dear, this is really bad. We adjust lots of things here. Do we send another sample off? Does that take another 2 months to come back?
If you let him answer you, Councillor Kerr, we'll find out.
I mean, again, these are probably more issues under the permit, but rather than planning. But yeah, I mean, the sampling, the time it takes to test is variable depending on the sample, depending on the test that the chemical you're testing for. So it's days, generally days, I think, to get results back. In practice, if the result, I think in practice, how this really works is that the continuous monitoring. So if you control in a combustion process things like the oxygen and the temperature, then the rest really follows. And so that continuous monitoring is a very, very strong indication of whether you're going to be complying with the other limit values. So if you are having problems with your temperature and with your oxygen and the rest of it, and the continuous monitors, then that's going to be indicative, of other things not working properly, because the idea is that you're burning the waste very, very effectively, very, very hot, so that you don't get any emissions. If you imagine when you have a bonfire and it's a bit wet or it's a bit colder, you get lots and lots of smoke. The hotter it is, then the less smoke you get, and it's the same theory. I'm not sure I can answer the question about, how long this could go on for in terms of the testing and in the commissioning phase, but logistically and practically, there can't be a unending commissioning phase.
So thank you, Carl. I believe it's a bit unfair to ask you that question because that's part of the permit. Right. But
hope that helps anyway.
Mr. Clark, would you like to add something about the chimney condition?
Thank you, Chair. Yes, removal of the chimney by condition. Yes, we can add that quite easily to the condition 1 on page 35. At the end of the period, the chimney shall be removed and the site returned to its former condition, or words to that effect, to secure at the end of the 18 months the building, the site as we know it now.
In terms of the money to do that, if the business has gone under?
Yeah, I think we have to take it on face value, like we do every planning application, that the business, the applicant, will still be there. We would be enforcing against the applicant or the landowner, if that is different, and it's their action that needs to resolve the condition, or be fined in the courts if it goes that far for non-compliance with the condition. Chair, can I come back as well on page 10 at 5.2? We do have a comment from the Health and Safety Executive. The HSE does not advise on safety grounds, so they've looked at safety of this application, knowing where it is with all the information that's been given to them. They don't advise against the granting of planning permission in this case. So hopefully that covers the issue regarding the proximity of the gas storage bottles. After all, this is a general industrial area where we've got the extra control, which Councillor Kerr has just been through with Carl, that the permit covers an awful lot of things which we wouldn't normally have controlled through the planning process. I'll sit roll back and project. So a lot of those that those explanations that the Environmental Health Officer gave are not really planning matters, they're permitting matters controlled with a permit. So if somebody had a concern to me about, I don't know, something happening on site, if it's not controlled by the planning process and by the planning conditions which you've got in front of you, it's potentially a control for the permitting regime which monitors and gives us more security, more comfort of what actually happens at the premises. Thank you, Chair.
Thank you, Paul. Councillor Pegg.
Yeah, can I just see clarification, please, if that's all right? Is this stack chimney similar in regards to the plant that's just been commissioned now down at Sinfin? Is it anything like that, or, you know, the controls on it, are they the same, or what do we know? Having been around the site, I just want clarification, please.
From memory, and I'm going back a long time, I think the stack for the one at Sinfin was something like 55 metres high. This is 20.
Sorry, it was the technical spec, not the height, the technical procedures around the emissions. That's what I was after more than anything else.
I would say, and the Environmental Health Officer would correct me if I'm wrong, that they're both covered by the same type of legislation, or one is X number of years old, so the legislation will have changed, but they're covered by the same type of legislation. And, of course, the Sinfin waste proposal is permitted by the Environment Agency under their own legislation, but they're applying the same legislation that our environmental health officers have applied, because this is a much smaller scale that the EA, Environment Agency, don't control it. We do as an environmental health authority. I'm sure Carl will correct me if I'm wrong.
Yeah, if I may, Chair. The monitoring system within the stack at this site is almost identical to the sort of monitoring system that they have. There is a minimum industry standard in effect, and both will have to meet that minimum industry standard. And so, yes, in that regard, it is very similar to the one at Sinfin.
Councillor Hessel.
Thank you, Chair. A couple of points, and unfortunately they probably are covered by the permit part of this rather than the planning, but I think they're valid points nonetheless. Firstly, it's my understanding that Derby's been highlighted as one of 6 areas in the country that have extremely poor air quality. As such, it's been identified as one that needs a clean air zone. And I feel that any kind of emission, however small, is only taking a backward step in us trying to improve our air quality here in the city. Secondly, the type of waste that's been processed on the site, SRF rather than RDF, I believe is similar to the type of material that was processed at Shows Waste Management on Slack Lane. And I think Councillor Pegg will attest to the problems that that particular material brought to the residents around there, and I think us bringing that to that type of situation to other residents in the city is something we should not place upon them. Thank you very much.
Thank you, Councillor Hessel. Paul.
Thank you, Chair. You are correct in as much as they are permitting matters. Air quality is a national concern. And again, our environmental health officer has been working very carefully with the highways transportation people with regards to the air quality in the city centre. This is outside of the city centre, but yes, it has implications. Air quality covered by the permit. SRF, the fuel, is covered by the permit, specified in the permit at the end of your report. So as a planner, I can't take those into account, and I would suggest that members shouldn't as well, because you've got that extra control. Thank you, Chair.
Councillor Kerr again.
The comment there about Slack Lane reminded me that I'd read somewhere in the papers that there was a need for a condition on pest control management at the top of page 16, but it doesn't seem to have been translated into a condition under paragraph 8.3. Can we Add that in.
I don't want to repeat myself, but it's covered in the permit.
It's covered in the permit? Okay. Because they just said, a condition requiring the submission of a detailed pest control management plan focusing heavily on fly control procedures to be agreed by the local planning authority before the development commences.
Those comments that are reproduced were written before the permit was put in place.
Okay.
And
So that's already covered.
But we need to make sure that we covered them and they're covered with the permit.
Should we put it in as an extra? Belt and braces?
Our legal officer will no doubt confirm with me that planning is encouraged not to reproduce and step on other people's toes in terms of legislation. Thank you, Chair.
Councillor Evans.
Thank you, Chair. I have concerns also about the air quality monitoring, the continuous monitoring. At the July full council chamber meeting, I put a motion forward in relation to the monitoring of the Synfin stack, and there was myself and one other councillor who voted in favour of it. Everybody else either abstained or didn't vote, and that was to have continuous monitoring remote from the site, independent of all the organisations over and above the bodies, whether it be the World Health Organisation, the Environmental Agency, or any other, so that we as a council could take the lead and know the air quality and before these sites are operational, so that you can monitor what's happening before, during and after. But that didn't come to any fruition. So without more stringent monitoring in place, then I have to say I'm not in favour of this application.
Thank you, Councillor Evans. Anybody else from the committee? Councillor West and then Councillor Woods.
Thank you, Chair. Just a quick one. Paul, I'm sure you can clarify. Just again, following on from Lucy's dotting I's and crossing T's. Point 2 of 5.4 on page 10. Combustion testing facility itself is intended to operate for a total of 12 months. Are we able to condition that? Condition number 1 at 8.3 on page 35 is condition relating to temporary permission for an 18-month period only, but there doesn't appear to be a condition for operation.
To come back to you, again, planning is concerned with the building and use of the building. It's easy to write a condition. It's much more difficult to have a defensible, justifiable reason why you want to restrict more onerously the operations within the building to 12 months. The applicant has said they want to do that, that's their intention, and again, we have to take it on face value within that 18-month window. And I think there was a question that Councillor Kerr raised previously. If we restrict them to 18 months, and I think she was going there, what happens if they want a bit longer? Well, they've got to come back here. And you're the people that assess, okay, 18 months might have been appropriate, but for whatever reason, we've had these issues, we're not accepting anything more. So you have the control to, within that 18-month window. There might be, again, something else in the permit, there is, that controls the operation of 12 months start-up and finish, but planning, I'm concerned with building chimney impact, simply. Thank you.
Thank you, Paul. I think, what Paul said is right. We sit here on, numerous occasions and we talk about application. It's important to remember that we're here to discuss what's in front of us. If somebody wants something for 18 months, that's all we can judge it on. If at the end of 18 months they come back here and say they want to extend it, then we look at the facts of the past 18 months and judge it then. Or if somebody wants to close after 17 months, then that's fine. But we can't preempt things by saying what happens after 18 months when we've only got 18 months of information. Councillor Woods.
Your opening words this evening, Mr. Chairman, was welcome to the Planning Control Committee. I've been on this committee on and off since 1979, and to me, planning issues are straightforward. They're about whether this building should have a chimney on it or not. All right, and the use that that chimney is put to and the effects that that will have. It is nothing to do with this committee, the matters that are covered by the permit. We've been told that many times this evening. Now, this won't make me very popular with the gallery, but I can see no reason, no planning reason, to refuse this other than to please people like Councillor Repton, whose contribution this evening was so much hot air it probably pollutes the whole of the city. But, you know, and the World Heritage Site will not be affected by this. I mean, we've had...
Mrs. Beck, please.
On purely planning grounds, I cannot see any reason that we would have to give and defend an appeal that would be sustainable at appeal. Therefore, I'm going to vote in favour of the recommendation.
Thank you, Councillor Woods. Anybody else? Move to the vote. All those in favour of the recommendation to approve? All those against? 6. 6 of them.
Hands up. Hands up. 5.
There's 5 for and 5 against.
5 for, 5 against.
Councillor Hassel, did you vote or did you abstain?
No, he's voted.
Sorry, Councillor Paul. Sorry, abstaining. Okay.
5 in favour and 5 against.
Yeah, and it's your...
Chair, Chair, you need to vote.
Sorry? Yes, I'll vote in favour of the recommendation.
Chair, if I can help, the vote was 6 votes in favour of the recommendation with 2 amended conditions and 5 votes against. And 1 abstention. It was granted planning permission. No, it's not minuted.
Moving on to item 2. Leverstock. Sorry. Yeah. Okay, moving on to item 2, which is Leverstock Code, pages 41 to 51. And to tell us about this is Sarah.
Thank you, Chair. Members will recall this item, which was deferred at the last committee meeting, for more information to be provided in relation to the numbers of occupants for the hostel, staff and management issues and security arrangements for the site. The proposal is for a change of use of former student accommodation at Laverstoke Court to a former hostel. In this case, the use is to house asylum seekers for short-term occupation of around 20 days. Although in terms of the land use, the proposal is straightforward for hostel use, with no alterations or extensions proposed to the building. Following the last meeting, the applicant has submitted a suite of additional information to support their application. Further information has also been submitted in the past week, and this has been circulated to you prior to the meeting. This information includes ground floor and typical residential floor layouts for the buildings, on-site showing room layouts and provision of ground floor activity space for the occupants. These plans show 4 single rooms and 2 family rooms per floor. An aerial photo of the site layout showing proposed uses for each of the buildings. The applicant has also confirmed that there would be a reduction in the maximum number of occupants for the building or for the site from 240 originally proposed to 225, and this reflects the room space standards which have been provided by the Council's Housing Standards team. Briefly summarised, the Housing Officer's comments assess the accommodation on the site against the Council's space and amenity requirements for bed and breakfast accommodation and temporary accommodation up to a maximum of 30 nights. Based on the room sizes, the following assessment of rooms on the site is that there are 92 one-person bedrooms, 23 three-person bedrooms, 23 four-person bedrooms, which equates to a potential maximum of 253 occupants. However, with the provision of 2 bathrooms provided on each floor, the occupancy is recommended to be up to 10 people per floor, which gives a recommended number of occupants at the site of 230. A supporting letter has been submitted from the potential operator, G4S, which gives details of the engagement with community groups which has recently taken place, and the proposed funding of a volunteer coordinator to be based on site to work with local organisations and coordinate activities on and off the site. They also state a commitment to reduce the number of asylum seekers accommodation in dispersed accommodation in the Abbey ward. We have received 3 further letters of objection. The basic main issues raised are wrong location, lack of facilities, buildings that should be put to an alternative residential use, concerns about adverse effects on the local community, and that the council should be taking more account of local feeling. The applicant has also offered to undertake pedestrian improvements to the footway on Peat Street at the entrance to the site. These are recommended to be secured by an additional planning condition, which would seek to agree the pedestrian improvement measures in the highway and their implementation. In support of the proposal, the applicant has provided a management and operations plan giving details of staffing levels, operation and security arrangements for the site. These are summarised in pages 47 and 48 of your report. The implementation of security measures and boundary treatment would also be controlled by condition number 4 in your report. The management plan confirms that the site will be permanently staffed and managed with procedures in place to provide a safe and secure environment for the occupants. The applicant has engaged in public consultation with the local community and organisations during the processing of the application in the form of a public exhibition which took place in August. In relation to the space standards given by the applicant and the Council's Housing Standards team, we are satisfied that the accommodation would provide a suitable living environment for the number of occupants which is proposed, which is now 225, for a temporary period being proposed. In our view, the applicant has provided an enhanced package of measures to ensure that a satisfactory and secure living environment is provided for the residents, which would not result in any worse impacts on the local amenities than the previous student accommodation which occupied the site. The use is therefore considered to meet the Council's local plan policies and amount to a sustainable form of development, so therefore we are recommending it for approval. You have 3 speakers.
Thank you, Sarah. I believe there are 4 speakers on this.
Oh, sorry,
Yeah. First one is Mr. Taylor from Lichfields. Good evening, Mr. Taylor. You have 3 minutes.
Thank you, Chair, members of the committee. I intend to focus on the changes we have made to address your concerns. In light of concerns, we have reduced our numbers to 225 in agreement with the Home Office and G4S. We trust this is received favourably. The Council's Housing Standards team approved 240 persons, and therefore 225 more than meets their requirements. There will be no overcrowding. We provided typical floor layouts to officers and a breakdown of the sizes and mix of accommodation within the management plan, which you've heard before you tonight, with no more than 10 persons per floor, and each users will be restricted to the floor they are living on. On a strategic level, G4S have committed, pending planning approval, to an overall decrease of the number of asylum seekers in Derby, which we trust is welcomed. This will be achieved by not procuring any further dispersed accommodation. And specifically for Abbey Ward, we have confirmed that G4S will not reuse their dispersed accommodation. So over time, the number of asylum seekers living in the ward will reduce, with each vacant property returning to the market. The advantage of reducing the number to 225 means we can address your concerns over idle time and how we integrate learning and activities into the running of the centre. We now have an entire ground floor dedicated to activity space where Urban Housing Services will work with the voluntary organisations to provide activities on and off-site. To ensure this will be achieved and not create a burden on the existing voluntary sector, UHS will appoint a volunteer coordinator based on the site funded by G4S and UHS. This works extremely well in our Wakefield Centre where we have a comprehensive and varied programme of activities. Staffing was a previous concern, and in our management plan we have confirmed that when at full occupancy 20 staff will be employed, including 2 overnight security personnel. This is in addition to the service migrant help staff based in the building and the aforementioned volunteer coordinator. These staffing numbers are robust and tested in our other centres and mean we are certain in our ability to operate effectively. Community liaison is key for all stakeholders, and we have committed in our management plan to effective operational engagement. We will keep officers and members updated on progress, and they will be invited to site prior to opening. We will play an active role in the established multi-agency meetings within Derby. In addition to direct contact, we will hold quarterly meetings locally to engage with local stakeholders. Equally, we are open to engaging with the Council's area coordinator and working with them. Site security and safety is covered in the management plan, includes an upgraded CCTV system, monitored 24 hours a day. Security staff will be on site day and night undertaking security checks. In our experience, users pose no greater risk to public safety, and equally the police have not raised this concern. We trust, Chair, that we have adequately, comprehensively addressed all your previous concerns and that you can support your officer's recommendation to support. Thank you.
Next up is Mr. Toon. Good evening and welcome, Mr. Toon. 3 minutes.
I'd like to thank the Chair and members of the committee for allowing me to speak in objection to this planning application. In my view, the revised proposals do not give adequate assurance on the 2 critical issues of occupancy and security. The revised proposals refer to a need for twin occupancy and family units for 3 or 4 people. The vast majority of the rooms are small, with a floor space of only 10.37 square metres. These could only be used for twin occupancy by installing bunk beds, but the total floor space would fall below the minimum acceptable level set by Derby City Council space standards. The smaller family units only meet the space requirements for 3 people by including an unusable area around the door. In reality, therefore, these rooms are only fit to accommodate a maximum of 2 people. Even the larger family units only just meet the space standards for 4 people. And this would necessitate couples who wish to maintain a full conjugal relationship to do so in open view of their children, as everything would be happening within the one room. This violates basic human rights and presents a serious safeguarding issue. In addition, using any of the larger spaces for multiple occupancy takes away virtually the only facility which has been allowed for individuals with disabilities. And no planning application should be approved if it depends on people with disabilities being treated less favourably by depriving them of any additional space required to accommodate those disabilities. In terms of safety and security, the staffing levels proposed give no assurance to either the local community or to the asylum seekers themselves, as the majority of staff will only be present at times when residents are free to leave the premises, and only 2 staff are guaranteed to be present at times when all the residents are required to be in the building. Although we are told that criminal activity has not increased in the vicinity of similar types of initial accommodation centres in Birmingham and Wakefield, this is not borne out by the statistics, which show that criminal activity has increased over the past 3 years by 27% in Birmingham and 28% in Wakefield, within a 1-mile radius of the initial accommodation centres. Whilst the causes may be complex, why would one want to place a significantly vulnerable group of people in the middle of a hotspot of rising crime? I would therefore advise strongly against approving this planning application. Thank you.
Thank you, Mr. Toon. Do we have a Mr. Harris? Good evening and welcome, Mr. Harris. You also have 3 minutes.
Hi, my name is Mark Harris. I'm here today representing my family and my community. On Monday, the 9th of October, I attended a community meeting attended by numerous people, and the number one concern was security. Families, young and old people, are all worried about a large influx of refugees and asylum seekers in their community, surviving on £5 per day. Some not speaking English or knowing our customs and laws. Every refugee will leave the building every day to buy food, and will be wandering our streets up to 10 p.m. every day. While the 225 asylum seekers and refugees are being managed and monitored by the numerous staff and security every day, as soon as they're released into the public, it's us that take care of them, not nobody else, you know, young, old, everybody. Laverstock Court is fit for purpose for the 180 university students that they housed before. G4S are trying to pack in an additional 25% above the original capacity and overcrowd the complex. And the 15 square metres rooms are not fit for purpose to hold 3 people and is against the policy. Part of the planning states it's a 3-year contract, and G4S contract runs out in September 2019, and they won't be taking this building until about Christmas time. So that is clearly breaching policy. Planning also states car parking for every member of staff. So each member of staff, being 25, would have to have 1 car parking space each. There are 10 charity workers that will be there throughout the complex, so another 10 car parking spaces. Nurses and an ambulance, fire engines, all requiring parking spaces. All these car parking spaces, just for that bit, come to 53. There's only 49. Now, planning also states, because like for like, the building's going to be like it was before, is every 4 people that's a resident of the building has to have a car parking space, and there's going to be 225 people, irrespective of if they've got a car or not, need the car parking space because that's the planning law, and that comes to another 53 spaces. Also, for every 30 people there has to be a car parking space for a coach, and the coaches take 2 car parking spaces up. So that's another 14 car parking spaces, as required by planning. Excuse me. 2 security staff policing 225 refugees in 8 buildings on 3 floors on a massive site is a security risk. It's a nightmare. If 3 people cause a problem in 1 room, how can 2 security staff handle that dangerous situation?
I'm sorry, Mr. Harris, I have to stop you there.
No problem.
Not a bill.
Thank you. Councillor Afzal.
Thank you, Chair. Whilst the approval of an initial accommodation centre is not desirable, I recognise that decision must remain for the committee to make. I will not restate my concerns in detail, but ask committee to consider these context of effect on the character of the neighbourhood, an increase in population density, detrimental impact on local amenities for the existing residents. I appreciate the reduction to 225 and the commitment to configure the accommodation to ensure people have a level of dignity in their living arrangements. I must stress, though, Chair, that the ratio of people to space and amenities confirms to our emergency accommodation standards only. If people will be staying beyond these limits, the HMO standards would apply, limiting overall occupancy to only 192 people. So, should you grant approval tonight, a condition on planning is required that any approval limits the use of the site for initial accommodation only. I am concerned that limited details have been supplied regarding residential engagement. There is a commitment to quarterly public meetings at the local facility and a complaints procedure. Assurances that this will be taken seriously and mitigated are still needed, and if possible, made a condition of any approval. I'm aware that G4S are in discussion with local voluntary groups to provide activities. These services are stretched, meeting the needs of existing asylum dispersals, and without additional funding, it is unclear how this will be achieved. A further assurance is needed that the plans will be in place to reduce potential tensions and how these will be reviewed. I believe Planning Committee can place a condition on the length of planning approval for a limited period, allowing a review of any negative impacts. So I would suggest that this would be appropriate considering the community impacts raised. I appreciate that this is a difficult decision for the committee and urge you to listen to the concerns of the local residents in the area. However, should your decision be to approve the application, I similarly urge you to invoke the conditions I have set out. Any approval limits the use of the site for initial accommodation use only and no other purpose. Resident engagement is taken seriously and concerns responded to as a responsible housing provider. Limit approval to 1 year to allow a complete review of the impact. Thank you for listening, Chair.
Thank you, Councillor Afzal. Sarah, would you like to come back on some of the concerns?
Yeah, thank you, Chair. There's just a few issues that have been raised. Just in terms of the occupancy and the space standards, concerns about the room sizes, I just refer members to the comments of the Housing Standards team, where they've looked at the assessment based on bed and breakfast and temporary accommodation. They do feel that family rooms are considered to be suitable for use as temporary accommodation. And that in terms of the space requirements, they are happy that they meet the Derby City Council's guidance on space provision and amenity. So, you know, we would take their guidance on board in terms of looking at the number of rooms and whether they're appropriate. Obviously, they've deemed that a limit of 230 would be acceptable to meet those standards. Obviously, the applicant has recommended request 225. So we feel that it does meet that occupancy standard. In terms of security, obviously I note the concerns of the objectors, but the management plan does specifically set out the management and security arrangements for the site, and we do recommend a condition which would obviously clarify the details of that security arrangement, which we could sort with our police liaison officer in respect to those. In terms of conditions, we can attach a condition to agree the terms of any community engagement that the applicant would have with the local community. And in terms of a temporary permission, you know, we could potentially attach a condition for 2 years if members wished, just to, you know, see if the use is acceptable and if any issues were raised during that time.
Thank you, Sarah. Committee members? Councillor Kerr.
Thank you, Chair. I thank the applicant for sending more information in, and that's been helpful, and also looking at the reduction in numbers, which I think is very helpful. I want to understand the mechanism, or what mechanism we can have to ensure that there aren't additional people living there, and that they aren't living beyond the period of time that we consider is acceptable for that density of housing. So how is that monitoring arrived at? How do we ensure that it's not becoming a problem? Within the information that was sent, there were some really positive comments about recognising the social and economic importance of protecting the environment and things like that. But there's also a statement that no laundry will be allowed to be hung to dry other than within occupants' rooms. Now, in my view, it does say that there's a washing machine and dryers available, but for people who are coming here from very different environments in some cases, the idea of not being able to hang one's washing outside to dry might actually be quite challenging. And the people in this country also think it's nice to have the fresh air blowing through our washing. So rather than have a statement like that, I would be much happier if we could condition that drying facilities for washing will be provided outside, so that people can, if they wish, choose to put some washing on a whirligig with some clothes pegs. Because that, in my view, is more environmentally friendly and something that we should be encouraging as a city, or not preventing. Also outside, and there was somebody who concerned about the number of parking spaces. My understanding is that asylum seekers not only are unlikely to have access to a car or own a car, they're also actually not permitted to drive a car. So the people who are living there will not have vehicles, and the number of people on site at any one time will not be the 53 or whatever that was suggested that you could have as a maximum. So I am not concerned that there's going to be a shortage of parking on site, but I think there's an opportunity for some of that outside space to be designed for outside recreation. And that will give people a reason for staying on site, whether it's to maybe put a basketball through a basketball hoop, or to be sitting on a seat chatting to a friend in the sunshine. And if we can put in a condition that would ensure that there is some outside space, on-site outside space, that would enable people to have a recreation opportunity in the open air, I think that would also be helpful. I thank the applicant for having expressed a willingness to change the main entrance onto and improve the footway access across the access onto Peat Street. And my lack of intimate knowledge of the area, it's obviously very clear from the view we've got up there at the moment that there are road access with curbed crossings onto the top of Drury Lane as well. And if we're able to do the same action on those Drury Lane crossings, and I think there are two, there might be one, there's certainly one, there might be two there, then I think that would be very helpful as well. Just because it enables people to move through a community with less impedance if they're walking, which is always nice. My final concern is that we're changing this into a hostel. There's been a suggestion that we should only allow it for 12 months. I think that that would be very difficult personally. I think the sort of support networks that will be built up over time, you know, from the local community, from local faith groups, the member of staff that they've talked about, working with our local area coordination, those sorts of networks aren't going to be immediately available. They're going to develop over time, and therefore to put a 12-month limit on that, I don't think will give a fair judge of whether this works. But if for whatever reason it doesn't work, or a number of asylum seekers coming to Britain falls dramatically and it is not needed, I don't want to think that this site can change to be a different sort of hostel without proper consideration, because it might be fine for this purpose with the management regime we've had described to us, but would we, for example, want it to be a youth hostel with people driving to Derby, run by the Youth Hostel Association, with a significant number, I would suggest, of more cars coming and going? It might be fine, but I think we ought to be allowed to consider it. Would it be a probation hostel? Would we be happy with that here? I think we should be able to consider it again. So if we are able to condition this as being specifically for this sort of hostel, I think that would be very helpful. Thank you.
Thank you, Councillor Kerr. Councillor Hassel.
Thank you, Chair. I also thank the applicant for the extra information. However, it didn't allay any of my fears that I had in the last committee meeting. The detail provided, while there was some, it was sketchy to say the least, in my opinion. I know Mr. Clark and Mr. Woodhead will probably frown when I say the reasons I object to it are because, quite frankly, of the people that are going to be there, and I know that we can't really object on those grounds. However, I don't have anything against people who may or may not reside there. I think, again, we need places like this, but it is in the wrong place. If I give the example of somewhere like Milestone House, which has people of a similar demographic, although not asylum seekers, they are homeless, they are destitute, they don't have a support network, we can only see the detrimental effect it's had on the city centre of people who are allowed to roam around during the day and cause chaos and mayhem. For me, there is also no detail on a check and balance of people coming and going during the day. What happens if they don't return? There's no real answer for that. And again, with cohesion in the community, the people that may come to reside there may have, certainly probably won't have English as their first language, so how will they communicate with local people and businesses? But also they won't have, be aware of English law, and also of how, you know, how we communicate as a community anyway. Again, I'll reiterate, we need places like this, absolutely, and we should be looking out for the people who need the help the most, but I'm afraid this is the right application in the wrong place. Thank you.
Look, can I just say, I mean, Councillor Hassel, you make it sound as though these are the first wave of, you know, immigrants that we've had in this country. These people come here not by choice necessarily, it's because they are asylum seekers. In terms of language, when we go abroad, you know, do we know their language? So that's not a consideration of any kind. I mean, I don't know why you raised that on, you know, an issue like that. It's quite emotive, yes, but it's not relevant to planning condition, and it's not relevant to how we make decisions here.
It's relevant to us as a community.
If you just please be quiet. We're here as a planning committee. We're not looking at other things. We're here to look at what's related to planning issues. And somebody not being able to speak English properly is not a planning matter. You know, they obviously come here, they have support. Now, you mentioned Milestone House, that's in my ward. Those people do speak our language, you know, they speak it very well. But does it stop them from committing criminal activities? You mentioned mayhem in city centre. It's not people that are migrants who are causing this. These are people that speak English, know English, right? So, you know, what you've just said is totally relevant to this meeting, and I think you should keep that, you know, for your election literature. Councillor Potter.
Thank you, Chair. I'm just a bit concerned about the site security. It's been mentioned there will be 2 security staff on the night time, but it says in the literature that the CCTV is monitored 24 hours a day from the on-site office. So if that's one security guard monitoring the CCTV, that leaves just one security guard walking around the site and securing it. I just think site security is a considerable concern for me on this. Thank you, Chair.
What would you like to see, Councillor Potter?
Obviously, Chair, if this is going to be viable, it needs a lot more security, not only for the protection of the local community, but also the people in the building. As it's already been said, we don't know who's leaving, when they're going, when they're coming, who they're bringing on board. we just don't know. And I don't think, from what I've seen in the literature, it gives me enough answers. Thank you, Chair.
Thank you, Councillor Potter. Anybody else? Councillor West.
Thank you, Chair. Just a quick question. It does say that when the hostel is fully occupied, there'll be 20 staff on site. It does talk of a minimum of 2 security staff on site at all times. I'm just seeking clarification as to how many staff would be living on site. We know that the number of occupants has been reduced to 225. We've also seen from housing that 230 would be the maximum. I'm just wanting clarification of how many staff would be there, making sure that wouldn't take it up to over 230.
Thank you, Councillor West. Anybody else? Councillor Harwood.
Thank you, Chair. Well, I had to say at the last planning meeting regarding this, I'm not going to say the same sort of things, but I would point out that I'm intrigued with the police report on page 43 and their comments at the bottom, and I go along with that, particularly in view of the fact that I know very well that at both the other 2 establishments that G4S have got, there are vacancies at both Wakefield and Birmingham, and why accommodate them not there and fill those particular places up? Because I think that this site is completely and utterly wrong. It might be needed, but unfortunately, in my opinion, it is not the right place. Now, G4S, I am told, have to deliver these people within 3 hours, let me just get it, 3 hours, yes, of their arrival. Now, I find it rather puzzling to me, if they've got to accommodate them within 3 hours of their arrival, where are they coming from? It's for Derby. Just a question. I mean, is it Skegness? You know, it really is quite puzzling to me if that's a requirement. Derby is not, it may not be a planning matter, but it's relevant to the situation. And as far as I'm concerned, I go along with the police. I'm not happy that sufficient consultation has taken place. I'm not happy about the same things that's been pointed out by my colleague, Councillor Potter, about whether they have sufficient people there at the time to undertake the security that this needs. And I will be doing exactly what I said at the last meeting. I will be voting against it.
Thank you. Thank you, Councillor Harwood. Anybody else? No? Would you like to address some of the issues?
I'll just come back on some of the things that Councillor Kerr raised. In terms of the length of the stay, the application refers to around 20 days, but the housing standards, they monitor the length of stay, and then their comments, they do say family rooms considered to be suitable for use as temporary accommodation, occupation limited to a maximum of 30 nights unless there are exceptional circumstances agreed by the local authority. So the housing team would monitor length of stays, and they would monitor any terms which go beyond that time period. Just in terms of the external areas and drying areas, we can attach a condition to agree within the sort of few months of the use being implemented to designate external areas and drying areas within the site. What else was there? In terms of the use of the hostel, we can't attach a personal permission to this type of use. It is a hostel use. And there's no real justification for us to tie it to this type of hostel use. So we would not be able to condition that. But in terms of site security, there is a condition 4 on the report. We can include details for a security management plan to be agreed and monitored as part of that condition, if that addresses those concerns. In terms of on-site staff, the management plan refers to a minimum of 2 security staff being on site permanently, but we don't have details of any other staff living on site, but I would presume that obviously security staff would be on site and would live on site permanently. And I think if members do have concerns, we can, like I said, attach a condition for a temporary use for these concerns or issues to be monitored.
Councillor Kerr.
Any comment on being able to look at the other curbed crossings at the same time, as well as the one on Peat Street, the Drury Lane crossing points?
The applicant has offered a condition in regard to Peat Street, because I think that's the access, the entrance that they're using to the site. I'm not aware of anything on Drury Lane, but obviously we have to be mindful that it's tied and necessary for the development. So in this case, we can do it for the Peat Street, but whether there isn't necessary to do it for Drury Lane, we obviously have to look at that post-committee.
Thank you, Sarah. Nobody else? The recommendation is to grant permission. All those in favour? All those against? Permission is granted.
Chair, Chair, are you just confirming that's with the 3 additional conditions? The security management plan.
You live on Drury Lane or in that area? None of you. We do.
The drying areas. Are we including those 2 additional?
Yeah, the application is granted with the conditions mentioned, i.e. the drying area, etc. Yeah, just to confirm, that was granted with the additional conditions. Item 3, Church Lane, Darley Abbey, pages 52 to 68. And to tell us about this one is Ian.
Thank you, Chair. First and foremost, in terms of updates for the report, members have been circulated technical amendments to the proposal and also a 6-point response to certain requests that were made during the members' site visit that was hosted last Wednesday. This meeting was attended by 4 councillors together with the applicant's agent. It was circulated, Councillor Kerr, but I have a copy if you want me to hand it over to you. One moment. Yeah. Have the other members received that document? It was circulated by Leslie Bright on Wednesday about 2 o'clock.
What time of day did you do it?
It was about 20 past 2.
Yeah, not when the school was coming in and out then.
Oh, sorry, the site visit was at 10:15. Chair, should carry on? Yeah.
Carry on, Ian.
Yeah. Chair, full planning permission is sought to redevelop this site, which currently accommodates a detached single bungalow and garage. While the address of the site is 1 Church Lane, Darley Abbey, the proposal sits at the western end of North Avenue, and permission is sought to demolish the existing buildings and erect a single replacement building that would accommodate 6 apartments across 3 floors. The rationale of the applicant is to provide a form of open market housing that would be attractive to individuals and couples downsizing from larger family-sized dwellings. The proposed vehicle access into the site to serve a communal parking area would be repositioned onto the North Avenue frontage, and the technical form of this access has been amended during the life of the application to address the requirements of Highways colleagues. Members will note that the proposal provides a reasonable level of on-site car parking, which is policy compliant, and cycle parking, together with an accessible building that accommodates a central lift and service core with individual mobility scooter parking facilities for the apartments, and that's something that members talked about last week. Although, Chair, on the face of it, this appears to be a significant intensification of development on this site, I consider that the architect has carefully designed a scheme that responds to its context. The site sits at a significantly lower ground level compared to Church Lane and Duffield Road, and the existing dwelling sited opposite at 3 Church Lane occupies a higher ground level. And the issue of ground levels and the topography of the site was something that we looked at last week with members. The agent has considered these levels and positively addressed these in his submission with the overall height of the proposed building, its roof profile and the angled footprint of the building to address its corner plot position. Chair, the application has generated a large number of objections, and these are comprehensively listed in your report. Councillor Repton is also here tonight to express his concerns together with other speakers. In this case, there are no objections to the proposal in terms of its position within the World Heritage Buffer Zone, and the site is located nearly 400 metres from the northern boundary of the conservation area and thus has no impact on its setting. The proposal is an acceptable form of development in terms of its overall height relative to neighbouring dwellings, and the position of windows on the principal front and rear elevations would not give rise to undue overlooking of the neighbours at 1 North Avenue and 3 Church Avenue opposite, which is also across the public highway. There are no objections to the proposal from all consultees in relation to highways, ecology and heritage components, and as your report concludes, there are no justifiable planning reasons to resist this application. Chair, I promote the recommendation and invite the speakers to address members. Thank you.
Thank you, Ian. We have 3 speakers on this, the first of whom is Jonathan Jenkins. Good evening, Mr. Jenkins. You have 3 minutes.
Thank you, Mr. Chairman, members of the committee. My name is Jonathan Jenkins, Chartered Town Planner, and I'm agent for Mr. Sterling of Commonwealth Homes. I strongly welcome Mr. Woodhead's detailed report and his recommendation for approval. This is a sustainable, previously developed site located at the very end of North Avenue. It's a cul-de-sac separated from Church Lane by a wide wooded verge, with convenient pedestrian access direct onto Church Lane and the bus stop. The plot fronts both North Avenue and Church Lane, but is set off Church Lane and sits 3 metres below Church Lane. The small 1930s bungalow is in poor structural condition and is surrounded by substantial 2-storey houses. The topography of the site allows for a taller building without adversely affecting the character of the street scene. Indeed, during the extensive pre-application discussions, officers concluded that the street scene would benefit positively from a replacement building of a more appropriate scale and height. The building will be similar in height to 3 Church Lane and will not visually dominate the street scene. The block of 6 2-bedroom apartments is carefully designed for a generation who are looking to downsize. The population profile for Darley Abbey is ageing, and there is a pressing need, and this is generally recognised across the political spectrum, for secure, accessible housing so that local residents can remain in their areas for longer. There is lift access to the upper floors, space for mobility scooters, wider hallways and wet rooms. The apartments are also designed to meet the accessibility standards for wheelchair users under the building regulations. The committee's site visit, Councillor Kerr made a number of helpful suggestions which have been taken forward in minor revisions to the scheme. Since the application was lodged, the applicant has already received considerable interest from nearby residents if permission is granted. The officer's report addresses the issues of overlooking an amenity, which he finds acceptable. The street is very lightly trafficked, being a cul-de-sac. At the committee site meeting, there was only 1 parked car on the street before the meeting started. In terms of people using Vicarage School for parking, this is a long way for people to drive to and from this site because it is over 400 metres drive distance away. So most people do not come and park at this end of North Avenue, and we have plenty of evidence to show that. The proposal includes 6 parking spaces and a pool car space. The proposal meets the City Council's parking standard, and there are no objections from the Council's highway team. The proposed apartments are unlikely to lead to an increase in on-street parking, and the committee site members were able to see for themselves how quiet the street is and how limited the impact will be. There are no overriding environmental constraints or heritage objections. This is a sustainable, previously developed site with a strong recommendation for approval. The proposal will help to meet local housing needs, and I commend it to the committee. Thank you.
Thank you, Mr. Jenkins. That was well timed. Can we have Mr. Hall? Good evening, Mr. Hall. Again, you have 3 minutes.
Good evening. Thank you. Firstly, the redevelopment of the site would be unlikely to be an issue if it were done in a sympathetic manner. However, this is not the case for the development that's proposed. If it goes ahead, it would blight the local neighbourhood to an unacceptable degree. I think the total of 69 objections submitted is a good indicator that this development is simply not wanted. It also needs to be borne in mind that although this is a Church Lane address, for historical reasons, the property is effectively part of North Avenue, and its effect on North Avenue must be properly considered. The three-storey height of the proposed development is not currently found in the immediately surrounding area and is grossly disproportionate to the existing houses. It would visually dominate the houses on North Avenue, particularly number 1. In combination with the width and depth of what is proposed, the resultant massing would be much greater than is the case with the existing housing. And the neighbourhood would certainly be changed for the worse. The proposed design would not fit with the existing houses and would visually clash with them. The architectural style and use of materials is different from that found in the adjacent area. In particular, the projection of the 2 front bays is of a scale which markedly differs from that found on the individual houses nearby, and the flat roof over the stairs and lift area is not a feature typical of the housing in the vicinity. When considered with the building height, this aspect of the development would be incongruous. While 2 bungalows have been demolished on North Avenue in recent years, the buildings that replaced them were houses where some attempt was made to make them fit with the existing houses. They are also a comparable height to the existing houses, unlike what is proposed here. The current open aspect enjoyed from the back garden of 1 North Avenue would be hemmed in on 2 sides to an unacceptable degree. The open outlook would be replaced by a wall and roof of about 9 metres height, seriously degrading the amenity of the back garden. There would be an unacceptable change of outlook caused by the overlooking wing of the development 3 stories high. The proposed development has insufficient provision for parking, 1 space per flat. Although the planning application suggests that the development will be likely occupied by older retired people, it is equally likely they'll attract younger couples who are both working and will be 2-car households. This is likely to result in overspill parking on the road outside the development and neighbours' homes, obstructing drives and pavements. It's also likely to extend to the turning head required by delivery and refuse vehicles to turn round. This could cause a real problem, especially when combined with parents' vehicles parking at that end of North Avenue to drop off and collect children from the nearby Old Vicarage School twice a day. For these reasons, I would strongly urge the committee to reject this really ill-thought-out proposal. Thank you.
Thank you, Mr. Hall. Councillor Repton.
Chair, this evening I've already mentioned the powers that you as councillors have in terms of localism. I just hope on this occasion you'll exercise those, because you're obviously not here to just rubber stamp officer recommendations, but to use your powers about what you think is right for this city and for those affected. Some of you have done that. I urge more of you to exercise those powers that you have for local people. In terms of this proposal, let's look at where we start from. We start from a single-storey bungalow. We're now proposing a 3-storey, 6-bedded unit, which will ensure that it's completely out of character with the street scene. It goes against the grain of local architecture and design of local properties. There's overmassing, overbearing, loss of amenities to surrounding properties, loss of light, loss of privacy, increased traffic movement and parking problems. These are parking problems against an area where we already have severe problems, which is basically a country lane, that's Church Lane, with the school which is just around the corner. That will only add to that. This proposal is adjacent to the World Heritage Buffer Zone and the conservation area. I think that this is too much for this area, and I would urge all councillors to reject it. Thank you, Chair.
Thank you, Councillor Repton. Mr Woodard, would you like to come back on some of them issues?
I think I'll just let Mr Thorley comment on the highways position, because we've, as I mentioned at the start, we've talked about improvements to the proposed access that now fronts onto North Avenue. Mr Thorley can tell you about the traffic conditions in the area and what considerations the Highway Authority take into account when looking at an application of this type, Chair.
Thank you, Ian. Right, it's your turn. You've been redundant all night.
Thank you, Chair. There's three main points I'd like to make. The first one is about traffic generation itself. When we look at these things, we look at what the peak hours generation is, and essentially we're only going to be looking at 4 vehicular trips in the peak hour. Unfortunately, I cannot argue that that's a significant impact. The second one is the parking provided, as has been said, does comply with the council's parking standards. Again, I can't argue that there's going to be a significant impact because it does comply with the standards. And the access itself, third point, that has been designed to comply with highway standards. So effectively, it all satisfies us.
Thank you. That was short and sweet. Members of the committee? Nobody? Councillor Kerr.
Yeah, I think something needs to be said, and the first thing is to say thank you for the small changes that have been made from following our site visit. They aren't as large as I would have hoped, but it isn't our job as a planning committee to redesign somebody else's scheme, so I can be thankful for small mercies. I appreciate the willingness to contribute a drop curb to encourage people not to drive but to walk across the road pulling their shopping trolley up to the bus. Is there a way of conditioning that?
Yeah, we can use an informative note for that, Councillor Kerr.
Okay. Yeah. I'm also mindful that this is being built for the long term. It's not going to be something that's only there for 18 months like the earlier application. And we know that within 15 years, people are going to be being told that you shouldn't be driving a car that actually pollutes. And therefore, people increasingly will be buying electric vehicles. Particularly this group of people who are likely to be downsizing, if they're right in saying this is going to go to retirees. It's likely to be people downsizing who may therefore have some spare cash in which to buy an electric vehicle. And can we condition that there are electric charging points available for people to use when they are parked here?
What guarantees it that they're going to be retired people?
It may not be retired people, but if it isn't, I have been grateful for the relocation of the bike shed because it is very convenient for the cycle route into town along the Derwent corridor. So they won't all, but I am disappointed that we aren't doing anything more about the solar opportunity. I am disappointed that we've not been able to turn the front door around because I think that makes things. And I really hope that we do get, maybe at the earlier stages at discussions with applicants when they're looking at the concept of reutilising a site like this, that we can actually push those issues forward. Because if we are going to have a sustainable city, if we are going to have a city which still has open spaces and is able to accommodate people, we do need to have this slightly higher density as we've got here. I went to a conference at the weekend and one of the speakers was highlighting...
Councillor Kerr, I'm trying to give you as much latitude as possible, but can you just stick to the application, please?
The speaker at this conference, Chair, was highlighting the importance of utilising sites like this one to be able to increase the density of housing so that we can meet our housing needs without extending into green open spaces. This is an area which has valuable green open spaces. I want them to remain green. And one way of not putting them under pressure, Chair, is to make sure that where we have a site like this, where redevelopment is asked for, not called for, but asked for, it's something that I think we should be able to look at. But I would like them to be more sustainable than this particular one is.
Thank you, Councillor Kerr. Ian, would you like to come back on any of them points?
Just mainly, Chair, I think that the final point that Councillor Kerr makes is the most valid one. It's a point we raised at last committee with the Cathedral Road scheme, that when you redevelop previously developed sites such as this and you gain units, then you take away the pressure on those greenfield sites, and the people of North Avenue will realise that we defended a public inquiry development of a Greenwedge site very, very close by, and we did that at Acorn Way, and we've released Greenwedges at Brook Farm and also at Mackworth College. So green spaces are under pressure, and sites like this that do deliver additional units are infinitely preferable to those greenfield releases. So I would, as I say, Chair, I promote the recommendation. I appreciate that this has generated lots of local objection, but I would suggest that if we were looking at a redevelopment proposal and you were looking at the building that currently occupies a site, it's not the most efficient use of that land. So I would suggest, Chair, that this is a sustainable form of development for the reasons set out in your report, Chair.
Thank you, Ian. Councillor Wood.
This is at the junction of the A6 and the A38. The A6 runs from London to Carlisle, as I'm sure everybody knows, and the A38 from the West Country at least to the M1 and to Leeds. Therefore, this type of accommodation would be very attractive to people who commute by car. There is no alternative to doing that. We use cars. On Planet Lucy one day it'll be different, but at the moment we use cars and we want to live where we can commute to easily by a car. Now, anybody who knows this area will know that several times a day Church Lane becomes totally impassable. There are so many parents, because their little darlings can't walk to school like we had to, but they completely block this road. If you were planning Darley Abbey nowadays, you wouldn't put a road like Church Lane there. It gets jammed up with another school at the other end and all sorts of problems. To make it worse is stupid. Now, yes, that site needs to be developed. Yes, it could take something much bigger than a bungalow. But what the proposal is something almost like Birchover Court on the other side of the road, the opposite, and we all know the problems that has caused. Now, this would be quite out of keeping with the local area. It is an over-intensive development of the site. I suggest that we should refuse it and ask the developer to go back and come up with something that fits this site much better.
Thank you, Councillor Wood. Councillor Harwood.
Thank you, Chair. Well, I endorse everything that Councillor Wood has said on this one, and I'm pleased about that, because there could be another one tonight that I will be voting against. However, if the committee are in favour of this, I did make the point last week that a former chair of the planning committee made the point that any property of this nature should have sprinklers attached to the building. And I've been through the conditions and can't see that, and I would like to say that we be put in as a condition. But I share what Councillor Wood, I don't think it's suitable for the area, another one, and I think it wants looking at.
Ian.
Yeah, just to come back on the sprinkler issue, it's something that Councillor Bolton was heavily involved in, and myself with the Think Sprinkler campaign, and we did and have done on many permissions included it as an informative note, but because it's covered by the building regulations it would be ultra vires to use it as a condition. So essentially it would be an informative note if members were minded to move the recommendation, Chair. Thank you.
Anybody else? Okay, the recommendation is to approve. All those in favour?
Can we just have a reminder about what additional conditions have or haven't been accepted?
Two informative notes about the pedestrian access on the highway and the internal sprinkler issues. I don't think that's technically reasonable at this point, Councillor Kerr.
Okay. with those conditions, all those in favour of the recommendation, which is to approve? All those against? Okay, the recommendation is lost. Will Councillor Woods, I take it you'll be coming up with the reasons for refusal.
What I said was over-intensive development of the site. Highways we're concerned about, but obviously we haven't got the support of our own, not our own officer, he only works to the policies we've got, but we haven't got the support of our own policy to sustain that. So I would go for over-intensive development of the site, full stop, subject to the advice of officers.
So what I glean from that, Chair, is over-intensive form of development in terms of its layout, scale, height, massing impact, and I'll flesh that out and... sorry, Councillor Kerr.
Can we add something on environmental impact as well, and its lack of ability to put solar panels on the roof and things like that? Just, it's a really weak case, everything we can grab at.
I think as Hugh Richards has advised before, Councillor Kerr, you don't load up for an appeal, you just hone your reasons for those that are technically defensible. So I think if we kept them at over-intensive form of development in terms of its height, layout and scale, I think that's probably the safest option. So I'll do something and let the Chair and Vice Chair have sight of that before it's issued. Okay? Thank you.
Thank you.
Do we have a nominated councillor for any appeal?
Okay. The final application to be considered tonight, 29 Princess Drive, pages 68 to 74. To tell us about this, Mr. Woodhead.
Thank you, Chair. In terms of updates, Chair, the necessary amended drawings referred to in the penultimate paragraph on page 69 have been received. The drawings include a ground floor window on the side elevation facing number 27, that's on the eastern side of the site location plan, which is not in situ, but as it is within the original side elevation of the dwelling, it wouldn't require planning permission in any case. Chair, on to the main report. This application seeks permission to regularise amendments essentially to a planning permission granted last year and referred to on page 70 of your report. The extensions are sizeable additions to the dwelling, but they are not unreasonable in design and massing terms given the scale, character and individual site characteristics of this part of Princes Drive. Particular concerns have been expressed by the neighbours at number 27 in relation to the adverse overlooking impact from the rear roof plane dormer extension and the potential for people to use the flat roof above the rear ground floor extension as a balcony. Now, James today has kindly put together the PowerPoint that shows the current application with the previously approved at the bottom. So the rear elevation you can see now includes at the top on the current application the dormer in the middle, the large window on the left hand side of the rear elevation is now slightly bigger and runs up to the eaves. The current application includes a Juliet style balcony on that window on the right hand side. And previously, if you look at the bottom on the left-hand side, there's a small door at first floor level and a line that denotes a screen for a sort of walk-on, a slender walk-on balcony. So that's all changed. And also at ground level, if you can just see the French doors with the person stood in front of them on the current application, that parapet roof has been included and they've just brought down the height of that, so it runs through with that with that soldier course that runs through from the left-hand side of the rear elevation. So they're the main changes, Chair. In terms of the dormer extension, it's essentially required to provide head height for residents gaining access up a staircase into the proposed roof space accommodation, and that's a photo from inside. I'm satisfied that whilst high-level views could be achieved over neighbouring gardens, I don't feel that this impact would be so significant to warrant refusal on the grounds of overlooking. Members will be aware, of course, that dormer extensions aren't uncommon in residential areas, and in the recent past, central government has made changes to the permitted development regime to permit householders greater freedom to carry out roof space extensions and enlargements. The neighbours at number 27 also expressed concerns about the potential use of the rear living room extension as a balcony, and with that eventuality in mind, condition number 3 on page 73 could be extended to embrace that control to ensure that it's never used in the future as a balcony. It's unlikely that it would be, because it's got a lantern style roof in the middle of it, so people would be kind of sort of foxtrotting around that a bit, so it's unlikely, but we can do that for the avoidance of any doubt. Overall, Chair, the changes to the design and roof profile of this dwelling are, in my view, within acceptable limits, and subject to those safeguarding conditions, consider that the proposals are reasonable in this case, and I'd promote the recommendation with those tightened conditions and invite Mr Curran and Councillor Ashburner to speak. Thank you.
Thank you, Ian. I haven't invited them yet. Mr Curran, would you like to come up? Welcome, Mr Curran. 3 minutes.
All right, that's great, thanks. Yeah, so the scheme was originally given planning permission in July last year, and the reason that it's here tonight is down to those two minor amendments. The reason for the dormer was, whilst it was being constructed, the builder was, you know, with the client, was weighing up costs in terms of doing a lot of like manual carpentry and then putting a new roof on it. And because he went down the route of putting a new roof on it, you know, he wanted to make it a habitable living space, like quite a lot of the houses along that road have got. So I sent an email, it was December last year, and I understand that it was going to be under permitted development because you could put a dormer on the back of a house, but because it was above 50 cubic metres, it required planning permission, which is why the application's gone in for planning permission. But, you know, I did a Google Street View, and there's 5 properties on that side of the road that have got dormer windows, and the view from that dormer is the same pretty much as the view from the bedroom out of the first floor window, so the views are the same. What else have I put here? And that's it really, that's all I've got to say.
Thank you, Mr Curran. I wish all the speakers were like you after 1.5 minutes. Councillor Ashburner, I take it you might follow suit.
No, thank you. Fellow councillors, thank you for the opportunity to speak on behalf of Mr and Mrs O'Sullivan of 27 Princes View. Can you now? Okay. The dwelling adjoins the application site and the property that is most affected by this proposal. This planning application has been brought to the attention of this committee because it has not been built in accordance with the July 2016 permission. As part of this objection, Mr and Mrs O'Sullivan have arranged for the height of the building to be checked by a qualified construction engineer using a Leica TS total station. According to the plans, it should be 8.5 metres high, but it is over 9 metres high. This is well outside the margin of error for this equipment and the acceptable tolerance for this council. Finally, an additional outbuilding is yet to be added. Given the errors so far, what is the chance of this being to plan? Mr and Mrs O'Sullivan have significant concerns about the scale and detail of the changes proposed. The extensions are disproportionate additions, and they are at odds with the scale and character of both the original dwelling and surrounding properties. The current proposal is materially different from the 2016 planning permission because of the second floor dormer window on the rear elevation, which has already been constructed. In addition, it is of concern that the French doors that have been installed on the first floor level give access to the flat roof of the single-storey extension overlooking Mr and Mrs O'Sullivan's garden. Their garden is extremely important to them and up until now has been relatively private. Current planting provides screening from existing neighbour first floor windows before the construction of this dormer. However, the proposed dormer includes a large window overlooking the garden. The design of the window, coupled with the second floor location, intrudes into the privacy of Mr and Mrs O'Sullivan's garden. In addition, the dormer structure is a visibly dominant, massive structure and discordant feature. Furthermore, use of the flat roof as a terrace accessed via the French doors is an additional intrusion into Mr and Mrs O'Sullivan's privacy. Paragraph 17 of the National Planning Policy Framework, NPPF, states that planning should speak to secure a good standard of amenity for existing and future occupants of land and buildings. In addition, Safe Policy H16 of the City of Derby Local Plan Review states that planning permission should be granted for extension to dwellings provided there is no significant effect on nearby properties in terms of, amongst other things, loss of privacy, and providing there is no significant adverse effect on the character and appearance of the existing dwelling.
I'm sorry, Councillor Ashburn, I'll have to stop you there. Thank you. Mr Woodhead, would you like to come back on anything?
Yeah, just a bit of a technical detail really, Chair, that the dormer in isolation, it would have been permitted development, but when we take into account the volume created, you also have to take into account what they call the resulting roof space, which is roof space of all other extensions. So because this has been extended, that relatively small dormer requires permission. And you may recall many moons ago, there was a job on Arlington Road where we had a side roof plane dormer which was caught by the same issue. It ordinarily would have been permitted development, but because other extensions had taken place, it failed the test. So yes, it needs permission by virtue of that. The changes have been outlined. You can see on the photograph, you can see the parapet roof in situ on the ground level extension, the slightly larger window on the left-hand side, and the French doors and Juliet-style balcony at first floor on the right. And gaining access from that, we can control, as I say, by condition. In terms of overlooking from the dormer, we have to take into account, of course, overlooking, but overlooking occurs you know, from many properties at various levels, and we have to have good reasons and concerns about undue impact to resist on those grounds, and I don't think they exist in this case, Chair, so I just promote the recommendation. Thank you.
Thank you, Ian. I think sometimes we have to look at things logically and, you know, put them in perspective. Because of the relaxation in sort of rules, we're getting people applying for front rear side extensions and the relaxation of rules in terms of loft conversions and dormers. You know, we're getting this. There is a lack of housing, and so because of that, people are applying for extensions. And I can understand sometimes, you know, neighbours or people from across the city objecting to this, but as a committee, we have to look at it from a planning perspective. And as, you know, Ian said, there's very, very little to refuse it on. And what we could have looked at was the dormer, but they are seeking permission for that. So, Councillor Harwood.
Can I ask a question, Chair? In view of the fact that this was found to be not being completed in accordance with the approved plans for the planning application we accepted in 642, how did we find out that it was being not being done according to the planning permission?
Pass. I don't know, Councillor Harwood. Normally complaints from neighbours. Neil Jackson used to often see things on his travels as well, so it would either be observed or a complaint.
Anybody else? Okay. Councillor Kerr.
I think, Chair, that the main issue here has been stated is the overlooking. I think when we had the internal view of the dormer there, the dormer is actually significantly larger than it would have needed to be to accommodate the stairs, both in terms of width and in terms of height. But it's probably not in permitted development terms unacceptable. But because you can actually gain access to the window, looking alongside it, it is then quite attractive to look out of that window, and it's something that can be done. So one solution would be for the window at the top of the stairs to be reglazed in obscure glazing, so that it would no longer be an attractive route to look out. And in that situation, even when the windows were opened, you could see out, but you'd only see down your own garden. So I think that would solve the main issue of overlooking from that window. The other view, if you look at the other large window that has been changed on the end of the other extension, it reminds me of the windows that you sometimes get overlooking a wonderful scene, sort of a holiday type view across a bay by the seaside, or maybe across a hillside. It's not the sort of wide open view you normally expect down a back garden, but it's obviously there. Because it's been built as a two-storey end there, we talked to an architect once about our own house, and he said, on our end wall like that, he said, well, why not make it into a mezzanine, and you can have a two-storey sitting bedroom. We thought it was a bit weird and didn't go ahead with it. But clearly it's something that architects have a mind to do, and to put a mezzanine in there would then again give you a very further forward, very overlooking view. And can we therefore condition that to ensure that we can't install a mezzanine floor into that position, which would then give overlooking more to the other side, but equally a bit to both sides, and that part of the extension is obviously set further forward. So those are my two requests, Chair, as things that we could be able to condition in terms of additional flooring inside and the opaque glass for that other window. Thank you.
Ian?
If members felt that the degree of overlooking from the dormer would be fairly excessive, I don't think it would be personally, in having seen many of these in many situations. You could attach a condition requiring its obscuration within a certain period of time, so within 3 months of this decision or whatever. In terms of the other point about the restriction of a mezzanine level, I don't think that would be reasonable, because if you just pan back to the drawings, James, please. If you can see what we've previously approved, left bottom, compared to current application, left top, then the increase in the height of that window is only relatively small. So we didn't include it on the previous permission. I think it would be unreasonable to go into those waters now. So if members wanted an obscure glazing condition for the dormer, it's not, in my opinion, reasonable, and the applicant would have the ability to appeal that condition if they felt it was unreasonable, but I'll pass it over to you. Thank you.
Thank you, Ian. Councillor Wood.
Just going to say it's totally unenforceable. If you go to the loo, as I just did a few moments ago, in this building, you'll see that you can look out the window, but not in the window. So how is an enforcement officer going to check whether that is obscured glass or not? And if they break the window and replace it with plain glass, who the hell's going to know? It's pointless trying to put that sort of condition on, and fairly ridiculous. This has been built. It's down to really a miscommunication and misunderstanding that this has gone ahead. I think the obvious thing to do to put everybody's mind at rest is to grant planning permission, which is what is recommended, and I move it.
Thank you, Councillor Wood. Again, I totally agree with you. I mean, trying to enforce or put a condition on saying, we want obscure glass, and for the applicant to go before an appeal and win, and we're going to, cost this council money for absolutely no reason whatsoever. So I agree with you, it's not necessary and it's not enforceable. Anybody else? Okay, the recommendation is to approve. All those in favour? That's carried. Thank you. The most exciting part of the evening, item 9, potential future site visits. Sarah?
We've got 4 potential site visits for you tonight. All of them are industrial in nature. We've got full application for Balfour Beatty, demolition of 3 buildings, change of use, storage on Rainsway. Second one is Rolls-Royce, new test bed on Wilmore Road. Third one is a reserve matters for a very large industrial unit, B8 unit on the Derby Commercial Park. And the third one is a variation of condition of the Sinfin waste plant, which we were talking about earlier, so landscaping.
I'm afraid as a tour operator, Sarah, you've failed. Well, thank you everybody. This brings the meeting to a close.